Hello, everyone, and welcome to this week's episode of the Rebel Roundtable. I am lucky enough to talk to very smart people on a weekly basis, and one of my favorite topics is IP law. So today I have Jordan Becker from Van Hoven IP Law here. Super excited to have him nerd out on all of the things IP related, especially the stuff that you all should be looking at as lawyers with your clients. You may not know IP, but you need to be able to spot the issues to refer them to people like Jordan. So thanks for being here, Jordan.
Well, thank you for inviting me. Appreciate it.
I get really nerdy when we start talking about technology and IP and things like that. And I'm not an IP attorney, so I just ask all kinds of fun questions. Tell us a little bit about yourself and about what you're doing these days with your firm.
Well, I'll start by saying nerding out is actually my natural state. So this is going to be really easy for me. Yeah, so I am an IP attorney and a registered patent attorney. I started my career as an engineer scientist in the aerospace industry, working on rockets. Did that for a few years before I decided it was time to uh, do something different. Went to law school, and then uh, took a job at a patent law firm after graduating from law school. And at that time, didn't really know anything about it. Just thought I'll give it a try and found out that I loved it and it was exactly what I wanted to do. And the reason is because it allows me to really dig into different kinds of technology on a daily basis, and not have to do the same thing every day for a long period of time, which I was doing as an engineer.
Right.
Um, and yeah, I've been doing that for now 30 years. So as you said, I'm with the firm of Van Hoven IP Law, and we are a four-lawyer IP boutique firm. So that's all we do is intellectual property law. So the majority of my practice is patents,
Okay.
um, but I like to think that I am not one of those fellows that just has a knee-jerk reaction to someone coming to me and saying, "Hey, I want to patent something,"
Mhm.
because sometimes that's the right thing for my clients, and sometimes that's not the right thing. And I want to do what's right for them and what's right for their business. So I am an IP lawyer,
Yeah.
although most of the time I'm working on patents.
Okay. Well, that's good to know. I mean, people always ask, even when I'm working with law firms, they're like, should I patent this? Should I trademark this? Should I copyright this? I'm like, those are all very different things that are solutions for things. So let's start there. Like, well, you work on patents mostly, but what does the patent actually protect?
Well, a patent protects innovation.
Okay.
So maybe we should distinguish that from other types of IP, right? So, basic types of IP are copyright, trademark, trade secret, and patents. So I'll go over the other areas real quick just to distinguish. So, copyright protects an original work of authorship. And now, work of authorship can be many things. It can be a writing, it can be a sculpture, it can be software code, it can be an architectural work, it can be a live performance. But copyright, I would say, is primarily used for things that are artistic, although in the tech field, it's used for software as well. But it's really easy. We don't need to worry too much about copyright because you don't really need to do anything to have copyright protection. It's automatic once you have an expression of an idea that's fixed in some tangible medium. Um, Trademark, on the other hand, protects branding. It identifies the source of goods or services. So it's kind of a totally different animal from really the other three, really.
Yeah,
Um,
it seems like that one always boggles my mind. Like I can never separate that or keep it in the same world as IP because trademark to me seems more like a marketing thing more than anything else.
well, that's primarily what it is about. Yeah, it is marketing, advertising, and making sure that consumers know what the source of the goods and the services are.
Yeah.
Um, then we come to patent and trade secret, and these are kind of like the yin and the yang, the two sides of the same coin, if you will. So they're mutually exclusive, patent and trade secret, for the exact same subject matter. But you can have both patent and trade secret protection on a given product, just different features, for example, or different aspects of a given product or service. So they're both protecting creativity and originality what I call innovation.
Hmm.
Um, and I practice primarily in the tech field. I should have said that at the beginning. Most of my practice is in software and electronics, some mechanical devices. So um, I know we're kind of like jumping back here, but I do a lot of AI software, for example, robotics, medical devices, things like that. So patents and trade secrets are the most powerful form of protection for innovation and technology. And the reason is because patents can be the protection that's afforded by patents can be defined much more broadly than the implementation that the inventors come up with. And that's the art and skill that a patent attorney brings to bear is taking an invention that the inventor comes to him or her with and abstracting it out to something that's much broader than that original invention.
Okay.
So, God,
No, when you said so, trade or patents and trade secrets are two of the same coin. Is that because patents are public and trade secrets are things that you intentionally keep secret? Is that what you mean? I just want to make sure that I was following that.
yeah,
Yeah.
that's exactly right.
Okay.
But trade secret by definition is a secret.
Yeah.
And when you apply for a patent, although it won't get published immediately, if it gets granted, it will definitely be published, in which case it's no longer a secret.
Right.
And many patent applications are published before they are granted anyway.
Right.
So you kind of have to make that choice up front, whether you want to protect it with patent or trade secret. And that's something actually that requires skill and judgment on the part of the attorney, um, and that maybe a lot of clients don't really think about too much.
Hmm.
Um, I think there are some patent attorneys that maybe do have a bit of a knee-jerk reaction, and just say, okay, let's just patent that. When in some cases it might be better to keep something trade secret.
And is that because a lot of times people can take a patent and I don't want to say copy it, but make some changes to it and then it becomes a generic thing that's out there? Is it easier to kind of adopt a patent versus a trade secret type thing?
Yeah, sort of. I mean, I think these days it's not that common. In fact, it's probably pretty rare for people to go out and read patents for the sake of, getting knowledge. And most companies nowadays know that it's probably not a great idea to read your competitors' patents for reasons that we can get into.
Yeah.
But the fact is, once you get a patent on it, it is public, and somebody may well find it, maybe one of your competitors.
Hmm.
And so when you're trying to decide, should I patent it or should I keep it as a trade secret, you ought to be looking at things like how discoverable will this be if I put it in product?
Hmm.
So will my competitors be able to reverse engineer my products without humongous expense or difficulty? And on the other hand, how easy or difficult will it be for me to detect infringement by somebody else?
Right.
So, and the answer to those is usually kind of the same. Right? It's either difficult or it's not. And if it's going to be really easy to discover it, maybe that's something that you would consider patenting.
For yeah, yeah, that makes sense. You talk a little about what trade secrets are because I feel like that part gets a little like no one talks about trade secrets when it comes to IP.
Yeah, well, I mean, it's basically any information that derives commercial value from the fact that it is kept secret.
Okay.
Um, and so it's not that difficult to protect it. You do have to take reasonable steps to, in fact, protect the secrecy of it. And that may mean educating your employees and having a consistent uh, way of treating confidential information and labeling it as confidential information. Um, Having exit interviews when people leave the company. But yeah, it's just a valuable secret.
So it's funny because the thing I think of with trade secrets is like the KFC chicken recipe or something like that, where you picture it being locked up in a safe that nobody can get to, things like that.
Yeah, yeah. Or the Coca-Cola
Yeah.
recipe,
Yeah.
right?
Yeah.
Those are great examples. And the problem there, though, is that if the secret gets out, once the cat's out of the bag, it's out forever. You've lost it and you can't get it back. Uh, if it was misappropriated by somebody, in other words, it was taken wrongfully, you might have, a lawsuit against that person, but the secret's still out.
Yep. Yeah, that's why I would guess the protection for trade secrets is all in the company policies with how they're protecting that secret. So,
Yes, that's right.
interesting. So I like talking about AI because I'm a nerd who hangs out with a lot of engineers, but I'm not one myself. What are you seeing in the wild, wild west of AI when it comes to IP?
Oh, wow.
A very loaded question. I could go on all day for this, but right.
Yeah, I mean, there's lots going on out there
Yeah.
regarding AI that we could talk about. So, on one hand, we've got uh, the generative AI, Gen AI,
Yep.
in many different forms, lots of different LLMs or large language models like ChatGPT and Gemini and Claude, and a bunch of others. And so there's lots of lawsuits out there by people who are unhappy with some of those companies that are producing those large language models for using what they view as their proprietary data to train them.
Right.
And so those are primarily, though not exclusively, copyright infringement suits.
Mhm.
Um, so there's issues of whether the training of those models with data that's obtained, from the internet, for example, is copyright infringement. And then there's issues whether the actual output of those models is copyright infringement. So this is still in the very early stages of those lawsuits. So we don't really have any definitive rulings from the courts. We've just got some very preliminary ones. On the other hand, we've got some stuff on the patent side about like what's patentable or what's copyrightable actually too. So as opposed to infringement, what can you protect in terms of something, an innovation in AI or an innovation made by AI?
Mhm.
Those are really interesting questions, which depending on how much you want to geek out, we could delve into.
Could be here all day. But yeah, I hear that one a lot from either other lawyers too. Like this was created by I used Chat GPT to create this. Is it mine? Who owns this if I use Chat GPT to create it? So yeah.
Yeah, well, so the fairly consistent position we're getting both on the patent side and the copyright side from the administrative agencies and from the courts is that if it's entirely generated by AI, it's not going to be protectable from both patent or copyright standpoint.
Okay.
On the other hand, if there's a human contribution that's combined with the output of something that AI generates, then at least the human contribution is potentially protectable under patent or copyright.
Hmm.
Again, few, if any, test cases
Right.
out there so far. So it'll be interesting to see what happens.
Well, I think that's the hardest part is that's the way the law has always worked. Something changes and then the law, they try to apply things from like 100 years ago and trying to keep updating it and seeing it. So I think the law is always behind the trends. So
It's true, especially with technology. The law is always way behind that.
yeah.
But one area that I've been focusing on for a long time is patenting innovations in AI. So in other words, improvements to AI or using AI in innovative ways. And so, there are interesting questions about, sometimes we can patent those things and sometimes we can't. I would say usually we can, but that's kind of an interesting area, I think.
Yeah. Yeah, it's interesting too that a lot of people don't realize what they have sometimes. They don't realize the things they should be protecting, even if they do create them, thoughts through AI. I always tell people you probably have more IP than you think. So, what kinds of assets are people overlooking? Businesses, lawyers, whoever that are probably IP assets.
I don't know if it's the kinds of assets per se that people are overlooking. I mean, in my practice, I deal with technology.
Yep.
I don't deal with pharmaceuticals or anything like that. Um, so really, it's about software
Okay.
primarily and hardware. And on the hardware side, I don't think there's any particular kind of
Mm-hmm.
invention that people overlook, except maybe certain kinds of software, because there's been this myth out there for many years that software isn't patentable, and that's totally wrong. Many, many decades ago, that was the case, but clever patent attorneys still found a way around it by making their patents on software look like hardware patents.
Yeah.
Um, but it's actually been the law since I started practicing more than 30 years ago that software is in fact patentable under the law. Now, there are some kinds of software that are more challenging to patent than others, but I think because of that myth, some people wrongly assume that if they're developing software, they can't patent it. I've encountered quite a few clients and potential clients that were really shocked to find out that they could be patenting what they're working on.
I've actually heard that several times because everyone thinks it's the expression, the copyright side of it. It's not necessarily the patent side. So it's good to debunk that myth.
Yeah.
Yeah. What in the software world are you seeing a lot in the AI space then? Of not that you can talk about trade secrets, but are you seeing a lot of people trying to patent various AI technologies?
Oh my God, it's yeah. A lot would be an understatement.
Okay.
And that's been going on for quite a while, actually, before it hit kind of the public consciousness a couple of years ago, when ChatGPT kind of came into, the public sphere. But that certainly accelerated things. And so I would say a huge segment of my practice now is patenting AI related innovations.
Very cool. I mean, there's just so much opportunity there. There's so many things, and the innovations moving at such a fast speed that trying to keep up with it is beyond what people can probably do on their own, which is why they're using AI to do some of it.
Right.
What are some of besides the software not being patentable, are there other myths that you see out there, other mistakes you see people making?
Yeah, one mistake that I've heard quite a lot is people assuming that they can only patent their invention if they've got a working model.
Okay.
And that's absolutely not the case. Um, the law is that if you can describe it in a way that a person of ordinary skill in the relevant field can read the description and build it without significant guesswork.
Mm-hmm.
I'm paraphrasing
Yeah,
the
yeah.
law actually, but you can patent it. So you just need to be able to describe it on paper, basically.
That's awesome. I mean, that's actually very interesting. I didn't realize that either. And again, things that's why I would call an IP attorney if I wanted to do any of this.
Yeah, and I shouldn't say on paper. I'm dating myself, but if you
Right.
can describe it digitally, electronically, whatever.
Well, and I think that's a good point though, because there are a lot of startups out there. There are a lot of they have the idea, they maybe have written it down, maybe have created something yet, and they should probably get you involved earlier rather than later at that point, would be my guess.
That is true. Well, they should get some
Some people.
IP attorney involved really early in the development process because IP is inherently time sensitive,
Mm-hmm.
um, particularly patents.
Yep.
So it's possible for a day to make a difference in the patent world. So I'm not trying to scare
Okay.
anybody. It doesn't happen that often, but it does sometimes. Because, like you said, things are developing so fast in
Yes.
technology, especially in the software field, that lots of people are working on similar things.
It's really funny almost sometimes when you hear something very similar, but they came from two totally different spaces, just because, again, everyone's moving at the speed of light these days and figuring things out. Yes.
Very true.
Well, and I mean, all lawyers say that. All lawyers say get your professionals involved early, and most of the time we're cleanup crews trying to fix because they didn't get people attorneys involved early enough in the process. So.
Yeah. And I would say, to the attorneys out there who are not IP attorneys, if you have clients that are doing something innovative or creative,
Mm-hmm.
and if they don't already have IP counsel, well, I mean, even if they do, you could ask them this question. Well, two questions really. First of all, are you doing something innovative that's going to be advantageous to your business.
Right.
So that's a two-part question. Are you doing something innovative? And is that innovation going to be advantageous to your business if you can have exclusive rights to it? So if the answer to both of those parts is yes, then that's a sign you probably ought to talk to an IP attorney.
It sounds like you should be a really good referral partner for especially business formation attorneys who are setting things up. So,
I get a lot of referrals from business attorneys, yeah.
yep.
And likewise, I refer out to business attorneys.
Yeah. It's interesting though, all the collaborations and all of the work that can be done together between different practice areas, just because there is the IP world is very specialized. I was in bankruptcy, it was very specialized, and crossing over into all these other areas is always a possibility. So it's very interesting.
Absolutely.
Yeah.
Yeah, I mean, these days we're all specialists, right? Um,
Hopefully.
it's it's almost impossible to be,
Yeah.
a generalist attorney these days, although I'm sure there are some out there, but
Yeah.
um, I
Yeah.
don't know very many, if any.
So, because I have to wrap up the conversation and keep my episodes less than like 4 hours long when I start talking about nerdy things, where can people find you at?
So they can email me at Jordan that's JORDAN at VHIPlaw.com.
Okay.
That's probably the best way to do it. I'm also on LinkedIn, Jordan Becker. It should be pretty easy to find.
Very good. And I will also link it in the show notes when we're done here. So, but that's great. Thank you. Any last tips before I cut us off?
No, I don't think so. I think we've covered a lot, but I want to thank you very much for having me on the show.
Well, thank you. And everyone else, tune in next Friday for the next Rebel Roundtable.